1. Advise the agent you wish to make an offer on the property and have them draw up the documentation so you can have your lawyer check the sale and purchase agreement before you sign it. Note, some agents will not like this and will possibly attempt to persuade you into signing the document. Do not be fooled by this or anything they say, as you have the right to have your lawyer check the sale and purchase agreement before you sign it. If they will not process your documentation so as you can have your lawyer check it before signing, then you may need to advise the agent that you will be considering making a complaint to the Auckland District Law Society and the Real Estate Institute of New Zealand about their failure to comply with guideline articles laid down and approved by the Real Estate Agents Authority in the New Zealand Agreements Guide, specifically important things you need to know, page 2. Have your lawyer check the sale and purchase agreement before you sign it. If the agent or seller still refuses to process your documentation so as you can take it to a lawyer or have your lawyer view it before signing, then advise them that if you suffer financial loss from their failure to proceed with the processing the sale and purchase document, you reserve the right to seek legal redress. 2. Advise the agent you will have your lawyer contact them and forward an offer. Do this if you have no luck getting a copy to take to your lawyer before signing, and ask your lawyer why you weren't able to get a copy to take to get legal advice before signing. Or do this if you just don't want to be pressured into signing a legal document you don't fully understand. 3. Ask the real estate agent to draw up the documentation and advise them to forward such to your lawyer for perusal, and tell them if your lawyer approves of the document you will sign it off and a copy will be forwarded to their office from your lawyer's end. Or if you have no lawyer but wish to forward an offer, or if your lawyer's office is not open, say if it's a holiday or weekend, tell the real estate agent you will need to find a lawyer and that you will call them and advise them of who you have engaged to act as your lawyer so they can forward the documentation for a legal opinion before you sign. Lastly, never ever sign a sale and purchase agreement without first consulting a lawyer. In my opinion, the law here is presently weak, for to expect folk that have no legal training to sign a pre-formatted document that they have no knowledge or understanding of, particularly first-time purchasers, is in my opinion callous, especially given the fact that a lot of agent-escorted property views are outside normal working hours, and of course the further conflict that the agent is able to prepare the document and present it whilst the buyer has limited options. A better way of removing this grey area would be to insert a 1 working day first-time property purchaser clause, whereby a first-time property purchaser could seek legal advice after signing and cancel the offer subject to that advice. I say this because it is here that a first-time purchaser is most vulnerable, because will they even be made aware by any or all agents or sellers that they can insert conditions, and even if they are made aware, will they have the legal mindset to fully understand what those conditions mean, given they have no formal legal training or could be completely unaware as to case law precedents already set around such conditions? Sneaky advice regarding real estate agents, sellers and offers. In my opinion, they will try and get you to sign this document as soon as possible, as it binds you to the seller and means they more than likely have closed the sale. This is what sellers and agents are trained to do. They are not breaking any law by persuading you to sign the sale and purchase agreement. They do so, in my own opinion, because they have nothing to lose and quite possibly will gain a commission, when you risk everything in doing so without first obtaining legal advice. Fact is, in my own personal opinion, some sellers or agents know only an idiot would sign such a document without first consulting a lawyer. They have nothing to lose by you signing the document, but you take a great risk by signing the real estate sale and purchase agreement without first consulting a lawyer, particularly if you are a first-time purchaser. There is no money to be saved here by not engaging a lawyer. Once you've signed that document, you are bound by it, and if you haven't added favourable conditions to the further terms of sale, you could be without redress, and the agent and seller could be laughing all the way to the bank. Further, if those further conditions are not worded correctly and laid down according to precedent, you might have a statement on a piece of paper that means nothing. Never sign anything without consulting a lawyer when legal documents are involved. Always consult a lawyer if you have any doubts about anything when buying real estate. Do not rely on the agent or the seller. Consult your own lawyer. Never sign anything without consulting your own lawyer, especially if you are a first-time purchaser. Important sneaky tip. Let's say you have signed a sale and purchase agreement and have regrets about doing so. You may cancel or withdraw your offer any time before the vendor, who is also known as the seller, accepts or gets your offer. To do this, you must contact the agent or agency or the seller, also known as the vendor, and tell them you wish to withdraw or cancel your offer. You do not have to give a reason as to why you want to cancel or withdraw your offer. Property titles. Other types. Life estate title, ownership, is good only for the life of the purchaser or person named on the title and is extinguished upon death, whereby the property ownership returns to the seller or the seller's agent or a named third person or entity. Here the purchaser gets full use of the property, subject sometimes to other agreements, but that use expires upon death, and put simply, the property becomes somebody else's property, usually but not always the person or organization that sold it. Some retirement villages offer this form of ownership. Stratum estate title ownership is in a unit or flat or apartment or house that is part of a much larger property, amongst other units, houses or apartments, etc., and the owner has the right to sell or loan against their particular unit or apartment, etc., but outside of that unit or house or apartment, etc., is deemed common land, where all owners share and enjoy in the use and maintenance of the common land, sort of like everyone owns part of and shares equally in the common areas. That is usually areas outside of their actual unit, house, apartment, flat, etc. Be aware it is preferable to have a fee simple stratum title as opposed to a stratum leasehold title, as with the leasehold you might find the lease cost can rise unexpectedly above what you expected. In my own personal opinion, especially if it is a new development, as some corporations or trusts set initially lower lease fees to attract more interest in the development, then may latterly increase these charges, sometimes substantially. Also, the resale value will usually not be more than if the title was stratum fee simple. This, in part, is why, price-wise, these developments may appear more attractive than other like but different title fee simple developments, i.e., common areas being areas largely open to all residents or casual visitor, but not so as to intrude upon one's usually predefined and agreed to or set area, like footpaths, pool gardens, bowling green, tennis courts, elevated stairways, car parks. Be aware, you as a shareholder in these common areas will be liable to share in the cost of their maintenance and upkeep. Furthermore, it is possible that some shareholders could have more exclusive areas attached to their house or apartment, unit, etc. They might have a garage and 4 car parks and you do not. All in all, make sure you fully understand what any seller is offering you and ask whether there are any shareholders that have exclusive rights.